Alright, yan. Magandang araw mga kabatas natin at welcome sa isa namang live stream. Mga kabatas natin, bayad utang tayo. Pasensya na kayo at hindi ko naharap na mag-live stream kagabi kasi nga nasa biyahe. But anyway, tulad ng sinabi ko, babawi po ako sa inyo at ito na po, no, i-discuss na po natin itong the curious case of Dr. Iggy Agbayani versus people of the Philippines. Dun sa mga hindi may alam kung ano nangyari dito, si Dr. Iggy Agbayani po ay nag-opera ng isang abogado. Mababasa naman natin yung mamaya. We will start with the letter of Dr. Iggy Agbayani and end up with the Supreme Court decision para mapagtagpi-tagpi, mapagtahi-tahi natin lahat ng mga ito. Pero syempre mga kabatas natin, yung kay Dr. Iggy Agbayani, gusto lang natin pakinggan yung kanilang mga punto de vista, ang controlling pa rin dito, at ako syempre bilang isang abogado ay yung Supreme Court decision. Ngayon mga kabatas natin, ito rin kasi ang problema dito. Dito sa Davalos Children's Clinic, naglagay siya dito ng isang post niya. Siya rin yung nag-post ng letter, no? Sharing a letter of Dr. Iggy Agbayani to the Supreme Court. Mga kabatas natin, ito yung magiging problema nila dito. Yung chilling effect nga na sinasabi nila. Sinabi dito, no, I am not comfortable faced with a patient with a demanding lawyer, parent, grandparent, aunts, and uncles. Ito rin kasi, no, personal take niya kasi ito Si Dr. Siguro Davalos, no? Doktor siya, mga kabatas natin, Yung doktor dito, well, wala namang problema na maging uncomfortable ka pag ikaw ay nagkakaroon ng pasyenteng ganyan. That is part of the job, no? Like for example, with us lawyers, yung maka-receive ng mga threats from people, even from senators, no? Threats about life, liberty, or property, of course, in a generic way, no? It's part of the job. Sabi nga nila, one of the most dangerous jobs in the Philippines, if not in the world, is being a lawyer. Why? Because it is adversarial. Laging may kalaban. Sabi niya, I think I am tiptoeing on thin ice. Thin ice. Well, ganun talaga, no? Ang problema dito, mga kabatas natin, no? Sabi niya, whenever I face a new patient lawyer, at the back of my mind, I'd rather have them seen by another doctor or at the emergency room. Ang problema kasi dito rin, pag ganyan, no, meron din sila yung tinatawag na Hippocratic Oath na they will not or they should take care of patients whatever it is their background, but in this case of lawyers and in their families there is apprehension and hesitancy. So hindi rin maganda ito that you will declare publicly that you are hesitating in embracing the Hippocratic Oath. Hindi rin maganda, katulad ako bilang isang abogado, maglalabas ako sa social media ng mga bagay-bagay that is against my lawyer's oath. Ano ang pinakamagandang example ng mga against sa lawyer's oath? Yung against sa due process. Yung paninira tungkol sa judiciary, sa mga korte kung saan ako kabilang. Okay? So, it's part of the job. Ngayon, dito, sabi niya ganyan, they have the same, sabi niya, this is true with my doctor friends, with lawyer patients' families. We have the same sentiments with lawyers and their families. Those are hazards of the trade. Katulad ng sinasabi rin kasi ng marami, lawyers can relate in relation to this kapag ikaw ay humahawak ng isang kaso na sensationalized, tapos ikaw yung defense. Bakit? Kasi nga, ang tingin na sa iyo ng mga tao, especially dun sa kabilang banda, masama ka because you are defending criminals. It doesn't work that way. Why? Because you are just doing your job. Okay? Dito rin, syempre, I do not want to be another Dr. Iggy. Sabi niya ganyan. So, puntahan na natin yung letter niya, no? Ito kasi sinabi ni Dr. Iggy dito, there can be no reckless imprudence or criminal complaint if it is not voluntarily done. Well, hindi ko maintindihan yung sinasabi niya dito na it is not voluntarily done. Kasi like for example, reckless imprudence, yung very common, yung driving, there is reckless imprudence, voluntarily done pa rin yun. Pero ito kasi yung sinasabi niya, Parang pilit siya, no? Parang pilit siya. Parang pilit siya dito. Parang sabi niya, it can only be voluntary if there was no legal obligation, no compulsion, no persuasion, and made without payment or recompense in any form of voluntary conveyance. So parang sinasabi niya dito, hindi pwedeng maging reckless imprudence kapag hindi ko voluntary ginawa yan. Ibig sabihin, pero dalawa lang kasi yan it's black and white eh. It's either you do it voluntarily or with duress. Pero parang sinasabi niya dito, dahil merong legal obligation, hindi pwedeng magkaroon ng reckless imprudence bilang isang criminal complaint kasi nga kung may legal obligation, hindi mo na voluntaryong ginagawa yon. I will beg to disagree here because, you chose to be a doctor and you swore under oath. Tandaan natin, even if pag kukunin kasi dito yung punto ni Dr. Iggy Agbayani, parang sinasabi niya na dahil may legal obligation ako na maggamot ng tao, hindi na ako pwedeng magkaroon ng isang criminal complaint na reckless imprudence kasi nga may legal obligation ako. Ang problema dyan, kahit may legal obligation ka, pwede ka pa rin naman kasing maging reckless o kaya imprudent, di ba? Pwede pa rin eh. Kung binarabara mo pa rin yan, kahit may legal obligation ka, pwede ka pa rin makasuhan. Di ba? Ngayon, sabi ganyan, I write as a prisoner of Manila City Jail and a doctor. I am not a lawyer but I have studied my case thoroughly with all the focus and benefit of time in jail. Yan, pinag-aralan niya daw yung kaso niya. I am a licensed physician. Pero alam niyo ito rin yung sinasabi ko kasi na when it comes to lawyering, I think it's best, especially if it is in court, it is best if we leave it to the lawyers because they know best. Ang isa kasi ng problema dito nila, sinasabi nila na nagkaroon ng negligence yung kanilang abogado. Marami naman ng Supreme Court decisions, mga kabatas natin, kung saan nagkaroon ng sobrang negligence ang isang abogado. Like for example, hindi siya naka-appeal, na nabigyan siya ng pagkakataon. Kasi syempre, ang rule sa batas natin is substantive justice still is supreme over technicalities. Okay? Justice still is supreme over technicalities. Sabi niya, I am a licensed physician and a highly trained and experienced orthopedic surgeon that still believes in the freedom of speech and of true justice. As a human being, I value independent and critical thinking because they are keys to our better perception of the truth. Well, naniniwala naman ako dyan. No? I blame the complainant, a lawyer who teaches criminal law and married to a physician, for intentionally filing a malicious accusation to make sure I suffered severely through 16 years of litigation and harassment and my eventual conviction affirmed with finality by the 3rd Division of the Supreme Court. Okay, mga kabatas natin, balik tayo dun sa sinasabi ni Fabri. Mga kabatas natin, walang issue po. Kung ito may finality na, and it was by the 3rd Division of the Supreme Court, well, it has the same force and effect. What is the force and effect? It forms part of the law of the land. Ang problema dito, balikan natin yung chilling effect na naman na dito, katulad ng sinabi ng doktor doon sa taas kanina. Parang ang mangyayari, pagkukuha sila ng lawyers at as patients, maniningil sila ng mas mataas na fees. Kasi nga, mas mataas yung risks. Kasi nga, baka pwede silang kasuhan ng abogado. Yun yung sinasabi nila. I don't remember though any cases na may na-convict na isang, please correct me if I'm wrong, no? May na-convict na isang doctor for reckless imprudence. Ito pa lang. Ang sinasabi nila, dahil meron na ito, hindi maganda ito na precedence sa mga tao. Okay? Sabi niya, in my heart and mind that a grave injustice had been foisted upon me because I am not guilty of any crime. Siyempre, that is his point of view, no? Well, meaning lawyers have told me that it is nearly impossible to reverse the decisions of the SC. But I live in hope, in humanity, and justice despite my experience and because I have seen so many people, some who I don't even know, wanting to help me fight for my cause of seeking justice, not just for me, but now also for the protection of the medical profession. Mga kabatas natin, ito kasi parang meron pa rin siyang hope na magkakaroon ng reversal dun sa decision ng Supreme Court. Mga kabatas natin, it is already affirmed with finality, and if it is final, tulad ng sinasabi natin, mga kabatas natin, there must be an end to litigation. Papasok ngayon dyan yung immutability of judgments. Ngayon, dahil may final judgment na hindi na pwedeng baguhin yan, tapos Supreme Court na ngayon gumawa, unless, of course, magkakaroon ng kakaibang pangyayari o kaya i-abandon ito o kaya i-overturn ng Supreme Court. Okay? Sabi niya, I have convicted of reckless imprudence and sentenced to jail for 1 year and 1 day. I have now served 3 months and 25 days of this sentence in one of the most congested city jails in the world. As you can imagine, this conviction has cost me and my family not only of mental suffering and humiliation, but also of tremendous anxiety for my future as a surgeon and a doctor. Mga kabatas natin yan kasi ang problema dito, no? You've been convicted for that particular crime and it is in relation to your profession, it is difficult to go back to that particular profession with a clean slate. Siyempre, tatatak sa mga tao na nagkaroon ka ng conviction in relation to your profession. Kaya maapektuhan talaga yung iyong pagtatrabaho. No? Sabi niya, I believe it is the first of its kind for a case, ako rin, no? I believe, of reckless imprudence to prosper in the courts as a result of a medical complication. This idea is further enhanced when veteran jail officers here in Manila City Jail told me that this was the first time to their knowledge that a doctor due to his profession was convicted for reckless imprudence. And that such cases of reckless imprudence are almost always due to vehicular accidents. Ito rin yung sinasabi ko, ito yung sinasabi ko sa inyo na very common, okay? They are always due to vehicular accidents. This was a complete eye-opener for me and so I began my research and study while in jail. Pero yun nga, problema, 5 months tapos you will study. Still, di ba, isipin nyo yung sa Supreme Court, 3 sila na doon sa NBank, di ba, na nag-decide. Still, even if you study hard enough, parang ganun din, no, vice versa. Even if me, for example, I study hard enough for 5 months or 1 year on how to be a doctor, I cannot still be better than a doctor. Diba? Ito, the record showed that the surgical instruments I used have been sterilized and all steps to avoid infection was adhered to me and my nursing staff. As a doctor and surgeon, more than 30 years, I can sincerely confirm that the infections occur almost routinely and likely even daily in all hospitals of Manila despite our best efforts because there are factors beyond our control such as the hospital, the sterility of the instruments used, and the factors associated with the patient himself. Ang sinasabi niya dito, mga kabatas natin, wala naman daw siyang negligence or imprudence, mga kabatas natin, no? Kasi nga, ginawa niya lahat ng steps to avoid infection. Well, if ang punto kasi dito rin, no, if this is a criminal case and you were accused of imprudence, ang magpo-prove naman talaga diyan ay yung prosecution. Ngayon, kapag hindi nila na-prove 'yon, ibig sabihin hindi mo nasunod yung steps para ma-avoid yung infection, you must have been imprudent. Pag naipakita nila 'yon, pero pag hindi nila naipakita 'yon, of course, there is no reason to convict. Ngayon, mga kabatas natin, it reached the Supreme Court. So, ibig sabihin, na-affirm yung conviction. Kaya lang, mga kabatas natin, merong technicalities kasi na problema. At yun ang pag-uusapan natin mamaya, no? Doon na sa Supreme Court decision. Kasi dito, let's focus on the letter of Dr. Iggy Agbayani. Okay? Tapos bago ako magpatuloy, no, condolences pala doon sa family ni Dr. Iggy Agbayani, no. Of course, it is always sad if anybody loses a loved one. Okay? Ngayon, ito. Mamaya pa sana ako sa technicalities pero baka makalimutan ko, 'di ba, attorney, pwede niya i-applyan ng probation. Hindi niya na pwedeng apply ho ito for probation because if you apply for probation, the remedies are alternative. Ibig sabihin, if you appeal, you waive probation. If you choose probation, you cannot appeal. Okay? Ito. It is the strength of the prosecution ang titignan ng court at kung final na ito, lalo na ang SC ang nagre-review, ibig sabihin nakita nila na may reckless imprudence. Okay, tuloy natin. Sabi niya ganyan, no? No surgeon can claim honesty that a post-operation infection will never occur. So ito yung ano nila, no? Ito yung kanyang claim. It is a post-operation infection. Anong ibig sabihin nun? Pagkatapos ng operahan siya, no? Yung kanyang pasyente, pagkatapos operahan yung kanyang pasyente, doon nagkaroon ng infection. Kapag ganun nga yung nangyari, walang kasalanan si Dr. Iggy. Di ba? Sabi dito, in my opinion, the most important and significant root cause of error or injustice in my case is the use of reckless imprudence resulting in serious physical injuries to charge me. Reckless imprudence requires that the act must be done voluntarily. The law states reckless imprudence consists in voluntary but without malice doing or failing to do an act from which material damage results. Kaya lang, yun ang pinaglalaban niya kasi na hindi voluntary yung kanyang act. Kasi nga, he is obliged by law and he was compensated for it. Pero syempre, still, if you do your trade, your craft, it's still voluntary because you still choose it. Tandaan nyo yung voluntariness ang tinitignan ho dyan, yung consent mo. Di ba? Magiging hindi voluntary ang isang bagay if you were compelled to do it by any vices of the consent. Like for example, you were under duress. You were intimidated. Di ba? Yun yung mga pangyayari. Sabi niya, no matter the outcome, be it slight, severe, or even death, the manner or the circumstances in which the act or cause was done is what defines it to be a crime or of the nature of civil damages. Ngayon, nag-iisip tuloy ako kung ito ba ang dahilan kung bakit hindi sila pinakinggan. Kasi nga, ang pinaglalaban nila dito, wala dapat krimen. Hindi nila pinaglalaban, ewan ko kung tama ako pero I want to think about this. Kasi it's the nth time na binanggit niya na naman dito na walang crime. Dapat hindi imprudence yan. Dapat hindi ako na-file ng kaso. Parang iniisip ko tuloy na parang ang kanilang argument doon sa kaso ay hindi dapat reckless imprudence yan. O wala dapat akong krimen na nakomit. Hindi yung hindi ko nakomit yung crime na yan. Nakita nyo ba yung gusto kong ipahiwatig doon na pagkakaiba, mga kabatas natin? Yung isa, sinasabi nila na hindi dapat krimen yung ginawa ko. Oh, shit. Ano yan? Sandali. Hindi matanggal. Ano ba yan? Dali lang ah. Okay. Balik tayo doon. Nakita nyo ba yung ano, no? Yung gusto kong ipahiwatig doon? Yung gusto kong ipahiwatig doon, baka yun nga yung hindi ko naman sinasabing tama yun o mali, no? Pero yun nga siguro yung tinahak nilang daan. 'Di ba? Ngayon, ito. No matter the outcome, blah blah blah, nabasa na natin dito. By definition, the word voluntarily as it is used in law means acting or done without legal obligation, compulsion, or persuasion, made without payment or recompense in any form, a voluntary conveyance. Okay? So yan yung sinasabi niya, ito. Ngayon, ang tanong ko, saan niya kaya nakuha ito? Search natin. Sa Collins Dictionary. So sa dictionary ito, pero sabi niya, by definition kasi. Pero sinabi na rin dito as it is used in law means. Sa bagay, ito kasi mga kabatas natin, magkakaroon ngayon ng problema dito sa definition ng legal obligation. Dahil mga kabatas natin, ang pinaglalaban niya dito sa legal obligation na ito, yung parang siya, no, dahil doktor siya, may obligasyon siya legally to treat patients. So dahil obligasyon na yun, ibig sabihin hindi niya na voluntarily ginagawa yon. Pero meron din tayo kasing sinasabi dito na legal obligation, mga kabatas natin, something that you are compelled to do. Anong ibig sabihin nun? Legal obligation, tulad ng for example, magbabayad ka ng utang. Yung pagbabayad mo ng utang, ayaw mong bayaran, pinilit ka ng korte na bayaran yon sa pamamagitan ng isang Supreme Court decision. Nagkaroon ka ngayon ng isang legal obligation. Di ba? So, yung mga legal obligations na yon, iba rin kasi yon doon sa legal obligations kung saan you swore, no? You swore to do something. Katulad ng nasa Hippocratic Oath nila. So doon tayo ngayon magkakaroon ng issue at doon sana magandang magkaroon ng linaw dito. Kasi nga if this is parang adopted, if this A and B, mga kabatas natin, ay adopted nga dito sa Supreme Court decisions natin or as a particular law that defines legal obligation, kailangan maging specific. Okay? Kasi ito, tandaan nyo, voluntary pa rin ang ginawa mo even if you were persuaded. Sabi niya kasi dito, without compulsion or persuasion. For example, ito mga kabatas natin, if you entered into an amicable settlement. Ito, tumalbog yung cheque, BP22. Nagkaroon kayo ng agreement. Pinersuade ka nung kabilang party na magbayad na lang. Di ba? Magbayad na lang ng ganon. You were persuaded, pero it does not mean na hindi voluntary yung ginagawa mo. Kaya nga pag gagawa kayo ng amicable settlement, tapos pipirmahan nyo yon, ilalagay nyo yung inyong mga pirma doon at sasabihin mo na o sige, babayaran ko itong amount na ito because you were persuaded by the opposing party na tanggapin yung amount na yon bilang utang mo. Hindi pwedeng sabihin na involuntary yung act mo of admitting that you have that particular utang dahil sa isang tumalbog na cheque because you were persuaded. Diba? So maraming pagdilinaw na kailangang ilagay dito sa legal obligation na yan for it to be adopted in Philippine law. Kasi pag sasabihin natin na hindi voluntary, if you were persuaded, for example, to enter into an amicable settlement, sasabihin nila hindi voluntary yung pagpirma mo dyan, di ba? Because my persuasion, kinumbinsi ka lang nung kabila na pumirma, it goes both ways. Parang kunwari, ang utang mo sa akin 100,000. Dahil kinumbinsi mo ako na ibaba na lang yung utang sa 50,000 kasi nagpaawa ka, Hindi ibig sabihin hindi na voluntary yung pag-enter ko into a settlement with you because I was persuaded. Ibig sabihin voluntary pa rin 'yon. 'Di ba? Ngayon, made without payment or recompense in any form of voluntary conveyance. Ito, so ibig sabihin ba hindi na voluntary yung act ko? Ibang definition to in my opinion ha. No, in my opinion, this is not the definition of the voluntary as we define it in law in relation to criminal cases dito sa Pilipinas. Okay? Kasi sabi niya made without payment or recompense in any form a voluntary conveyance. Dapat walang bayad. Syempre, yung payment naman na ginawa na yon, that is in exchange of services 'Di ba? You were compensated for your services. Ibig sabihin, voluntary siya nagbayad, voluntary ka ring nag-render ng service mo. That's the nature of that particular contract of services. 'Di ba? Ito, a patient consults a doctor for a health problem in the hope of finding a cure, persuading or compensating a doctor to act based on the agreement between parties, and the doctor is not a voluntary action but a joint agreement or partnership with the patient. Pero yung agreeing is a voluntary act. The entrance in the partnership is the voluntary act. Di ba? My case is entirely different from a true case of reckless imprudence where, for example, a pedestrian accidentally and therefore without malice gets hit by a driver-bearing vehicle. Well, tama naman siya dito, no? Tama naman ito. Kasi ito common case na ito, yung nabangga. Without malice din. Without malice din yung sa kanya. A civil case of malpractice, negligence, or incompetence, on the other hand, may be the right case to file under because the alleged cause is not act done in a voluntarily manner. Well, pwede, alam nyo, ako nga rin, mga kabatas natin. Pero like I said, no, I will side with the Supreme Court here because I am a lawyer, of course, no? Pero umpisa rin, no, before actually this particular case, I really thought that ito nga, no, yung malpractice or negligence or incompetence, ano lang siya, civil case lang. But now that there is a president, no, or a president, it can be pala, or it is possible to be a criminal case. Okay? Moreover, I learned that in published Supreme Court decision of a reckless imprudence resulting in serious physical case, defined the sentence of such crime to be a fixed 2 months and 1 day. Yet I am still here in jail now for more than, well, this will not hold water Kasi nga, the Supreme Court decisions form part of the law of the land. Okay, pupunta na tayo dun sa technicalities. Okay? Sabi niya dito, nag-put more weight daw on the procedural technicalities than my substantive human rights. No, substantive justice, substantive law. Pointing out, for example, that it was my lawyer who was faulted by the courts for causing the loss of my statutory privilege of appealing my case in both the RTC and the CA. In doing so, they also took my right to a fair trial that in my mere knowledge of the law should be given automatically to those accused of criminal cases. And despite putting the blame on my lawyer, all punishment was given to me alone. Ito sabi niya, no, parang kasalanan ng abogado mo pero ang pinarusahan yung kliyente. Ganto kasi yan, mga kabatas natin. The mistakes of the lawyer binds the client. No? So kung nagkamali yung lawyer mo, pagkakamali rin yun ng kliyente. Ito, and yet again, I discovered recently in another Supreme Court ruling, a criminal conviction was reversed on the grounds that a lawyer's inability to perform his duties should not be cause for any accused to lose his constitutionally given right to liberty. Yun nga yun. No? Ito, I therefore with hope and good intention, my fellow doctors, okay, na read and share this letter, okay na tayo dyan. Ngayon, mga kabatas natin, dito tayo sa Supreme Court decision. Ito yung kaso niya and it's been decided with finality, mga kabatas natin. GR number 215121, Dr. Benigno A. Agbayani versus People of the Philippines. Ang nangyari dito, mga kabatas natin, nagkaroon ng arthroscopy, tapos sinasabi na hindi sterilize yung arthroscope without taking the necessary precaution to avoid injury to said complainant. Okay? So, yun ang naging problema. Ngayon, punta tayo dito. Sa Metropolitan Trial Court, mga kabatas natin, ang nangyari dito, convicted. 2 years of prison correctional minimum. Nag-appeal siya before the RTC. Thereafter, on October 11, the RTC ordered him to file a memorandum of appeal. Okay? So, MTC to RTC. Actually, METC to RTC. Tapos, in order siya na mag-file ng memorandum of appeal. Rule 40 of the Rules of Court. Ngayon, instead of filing his appeal memorandum, he filed a motion asking for an extension of 15 days. Grinant ng RTC. Ngayon, nabigyan siya hanggang December 19, 2013 within which to file his appeal memorandum. However, he failed to do so. Bakit ba importante itong appeal memorandum na ito or memorandum of appeal? Importante yan, mga kabatas natin, because dyan iga-ground ng regional trial court kung ano yung mga arguments mo, ano yung mga assignment of errors mo doon sa desisyon ng METC o ng Metropolitan Trial Court. Of course, without your arguments, hindi makakapag-act yung Regional Trial Court. So, nag-rule yung Regional Trial Court, dinismiss for failure to file an appeal memorandum within the reglementary period. Sabi niya, I've prayed for the court favorably acted on accused appellant's motion for extension of time to file memorandum by giving him until December 19 to file the same. However, accused appellant failed to comply with the order of the court dated December 16, 2013. Sabi niya dito, no, 15 days, tapos 15 days, dito yung tapos nagkaroon ng extension, na-dismiss kasi nga hindi siya nakapag-file. Dito yung RTC, mga kabatas natin, wala nang choice dito. Okay? Wala nang choice dito yung RTC. Why? Because there is no ground to reverse the decision of the Metropolitan Trial Court kasi nga there was failure to file a memorandum. The necessary course of action is to dismiss the appeal. Kumbaga, walang ibang pupuntahan. Walang ibang pupuntahan yung kaso dito. Nag-file siya ng motion for reconsideration. It was denied by the RTC. It was held that despite the extension given to the petitioner until December 19 to file his appeal, he failed to submit. Instead, he filed two other other motions for extension, which were received by the RTC on January 15, 2014 and January 20, 2014 respectively through registered mail. Ngayon, nag-petition for review sila. Grave abuse of discretion on the part of the RTC for dismissing his appeal for his failure to file an appeal memorandum within the extended period. ang tinitignan ko rin dito, bakit grave abuse of discretion on the part of the RTC? Walang grave abuse of discretion on the part of the RTC there because the RTC only did its job. Wala naman siya magagawa doon. Kung ikaw ang hindi nag-file, then that's your problem. Pag yun lang, kasi ang iniisip ko na, pag ako lang like I said, I don't know this case personally, but for academic purposes lang. Pag ako lang, I will not attribute grave abuse of discretion on the part of the RTC. Kasi wala naman siyang grave abuse of discretion doon eh. Ang ipiplead ko o hihilingin ko sa Court of Appeals ay sana bigyan ako ng pagkakataon pa para mag-file ng memorandum. Memorandum of Appeal. Yun ang ihihilingin ko. Bakit? Kasi nga, may kasalanan ako eh. Tandaan nyo, the fault of the lawyer binds the client. So sasabihin ko, pasensya na, meron ho akong kasalanan, hindi ako nakapag-file. Pero, in the interest of justice, please, payagan nyo pa akong mag-file. Sana bigyan nyo pa ako ng pagkakataon para makapag-file. 'Di ba? Yun yung parang pag ako lang ha, well, academically speaking, tulad ng sinasabi ko, I'm not saying that what the lawyer did here is wrong because I don't know the case personally, but because this is a Supreme Court decision na maganda naman na pag-aralan natin yung mga pwedeng maging taktika kapag nangyari yung kaso na ito. 'Di ba? Kasi merong grave abuse of discretion eh. Kaya lang ang problema kasi diyan mga kabatas natin, kapag petition for review on certiorari na yung hindi naman certiorari, hindi naman Rule 65 to eh. Ano kaya ito? For sure, ordinary appeal pa rin ito eh. Di ba? Kasi it's still decision of the Supreme Court. Sorry, it's still a decision of the court. So it takes ordinary appeal. It takes the course of an ordinary appeal. Sabi dito ng ruling of the Court of Appeals, mga kabatas natin, the appellate court dismissed petitioner's appeal for lack of merit. It ruled that the right to appeal is not a natural right, nor a part of due process, but a mere statutory privilege which may be exercised only in the manner and in accordance with the provisions of law. Thus, petitioner must comply with the requirements of the rules of court, and failure to do so would result to the loss of his right to appeal. Dito nyo makikita mga kabatas natin, no? Sa mga tao kasi how difficult it is to win a case in the Supreme Court. Kaya maraming abogado ang nagwi-wish na magkaroon sila ng kaso na madidecidean ng Supreme Court. Why? Well, of course, in their favor. Why? Because if you appeal, no, katulad nito, MTC to RTC, RTC to CA, CA to the Supreme Court, napaka-technical nung mga galawan. Okay? Napaka-technical ng mga galawan. Hindi siya basta-basta. Parang yung nangyari dito, di ba? Doon pa lang sa MTC to RTC, medyo nagkaroon na ng problema. Imagine if you will be appealing, like for example, yung mga cases ko na in-example ko sa inyo, you will take in mind all the technicalities that accompanies an appeal. Tapos, with that, you will also argue accordingly. Diba? Sabi ni Ron Joshua, 65 po yan. Unappealable na po pag dismissal of appeal ang contested. Well, I don't think so. Kasi kung hindi. Kasi appeal is always, well, kasi dismissal of appeal namin para lagi yan eh. Lahat yan dismissal of appeal if you are the appellant. So, Ron Joshua, I don't think tama ito, no? I don't think 65 agad yan. Kasi ang 65, yun lang if there is no other remedy. No? And other remedy is appeal. And if you are an appellant, what results always, if you lose, is dismissal of your appeal. Okay? So I think this is still ordinary appeal. Pero syempre, correct me if I'm wrong. I don't know. I'm not a lawyer here, di ba? Tapos hindi na kasi alam yung intricacies eh. Pero maganda kasi dito gamitan natin ng critical thinking tsaka pag-aaral. Di ba? Sabi ni Mensrea, 45 yan. I think so too. No, this is ordinary appeal. Kaya di na binalikan ng SE yung facts and evidence. Tignan nyo. Ito. Moreover, the appellant court noted the petitioner failed to append to his petition the following information dated January 22, 2016, petitioner's affidavits. So ito, may mga hindi pa nangyari, no, na nagawa. Doon sa petition naman, dito, sa Court of Appeals. Yung mga affidavits, evidence of the prosecution, petitioner's comment and opposition, petitioner's answer, RTC order, halos lahat, no? Halos lahat hindi niya naisama. Sabi niya, Section 2D, Rule 42 of the Rules of Court, appellate court ruled that the petition for review must be accompanied by clearly legible duplicate originals or true copies of the judgments or final orders of both the first level and second level courts. Certified correct by the clerk of court of the RTC and requisite number of plain copies thereof and of the pleadings and other material portions of the record. Dapat isali talaga lahat. Tapos pwede rin maging ground for dismissal. So dito, ano siya, parang nagkaroon ng strike 2. Di ba? Moreover, the rules of court are designed for the proper and prompt disposition of the cases. Petitioner is mandated to file his appeal memorandum within 15 days from the notice of the clerk of court. Shall, sabi kasi dito, dapat mandatory. Ito rin, no? In relation to the motions for extension, yun nga, it lies within the sound discretion of the court to be exercised in accordance with the particulars of each case. So dapat hindi ka umasa na may extend yun. Unless of course it is provided for by law na extendable yun. Then wala magagawa yung judge. Pero dito, 2 beses siya nag-extend eh. Sabi dito, while it's true that rules of procedure are liberally construed to accord litigants ample opportunity to prove their respective claims, and in order to avoid a possible denial of substantial justice due to legal technicalities, it's also equally true that an appeal is a statutory right which requires the appellant to strictly comply with the rules of court. So, dininay yung appeal niya, nag-motion for reconsideration siya, no? Denied by CA. So ito, so 45 nga, no? Hence the petition for review and certiorari under Rule 45. 45 nga nito, final. Sabi na nga ba? Yan. Ito kasi mga kabatas natin, I just anong tawag diyan? Scanned this before reading this with you. Ito yung mga assignment of errors. Ito rin ang problema kasi kapag hindi ka magsasubmit ng memorandums, you cannot assign errors and you cannot argue the errors. So, madidismiss talaga yung kaso mo. Ngayon, whether or not the Court of Appeals gravely abused its discretion and erred in dismissing the petitioner's appeal for failure to attach all the pleadings and documents pertinent to the petition for review under Rule 42. Hindi ko talaga maintindihan ito. Parang bakit magkakaroon ng grave abuse of discretion kapag sumunod lang sa batas, sumunod lang sa rules of court yung judge. Siguro, failure to give a chance. Whether or not the Court of Appeals gravely abused its discretion and erred in upholding RTC's dismissal of his appeal for failure to file the appeal memorandum within the period of extension originally granted. Yun ang hindi ko maintindihan dito sa mga assignment of errors. Yan, no? Parang tulad nga ng sinabi ko sa inyo, if I were the person here, I would be asking for liberality of the court. For them to forgive me for the things that I have done wrong. and give me a second chance. Di ba? And give me a second chance. Parang ganun. Pero dito, parang a grave abuse of discretion, I don't see it. Whether or not the Court of Appeals gravely abused its discretion and erred in failing to consider and reverse METC's erroneous conviction of petitioner for reckless imprudence resulting in serious physical injuries. Ay dito sa number 3, okay ako sa error na ito. Di ba? Kasi yun titignan mo failure. Pero dito na rin Kaya lang, syempre, yun sa mga technicalities. Bago pumasok kasi, dapat yung technicalities muna. Ngayon, dun sa mga, dun sa mga, well, siguro i-discuss ko in a separate manner. Kasi mahaba-haba na rin ito. I-discuss ko in a separate manner yung technicalities na nangyari dun sa Supreme, dun sa, anong tawag dyan? Case ni Raffy Tulfo. Okay? Doon sa case ni Raffy Tulfo, hindi po na-dismiss yun based on a technicality tulad nga ng sinasabi ko. No? Totoo yon na hindi nabigyan ng kopya si Raffy Tulfo, kaya lang it was cured. Pinadalhan siya. Na-dismiss yung kaso because of lack of jurisdiction. Okay? Kasi tandaan nyo, ang isang kaso, nawawalan ng jurisdiction ng COMELEC kapag nagkaroon ng promulgation. Nung dinismiss yung kaso ni Raffy Tulfo sa COMELEC, wala pang promulgation noon. Okay? Ito, pinapaliwanag ko lang naman yung decision ng COMELEC dito. No? Wala pang promulgation si Raffy Tulfo doon. Kasi it was actually during the election, or the Friday before the election. So, ibig sabihin, may jurisdiction pa rin doon yung COMELEC. Then, it was cured. Tapos, nung na-file yun, merong motion to suspend proclamation because of a pending disqualification case. Then, eventually, pre-claim na siya, nawalan na ng jurisdiction ang COMELEC. Ganun ang nangyari. Okay? It's not based on the technicality. Okay? Ito yung argument ng petitioner. Petitioner claims that he submitted the following pertinent documents in support of his petition, blah, 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 blah. Petitioner contends that he did not submit the motions for extension as they were duly mentioned by the RTC in its February 26, 2014 order, and the said facts were not in dispute as to the information. The same was already set forth in METC July 29, 2013 order. He argues that his failure to attach all pleadings and documents is not a sufficient ground to dismiss the petition. Petitioners cite several instances in which the court liberally... Ito kasi yung sinasabi ko sa inyo You are asking for a liberal construction of the laws because you are the one who failed in complying with the rules. If you failed with compliance or if you failed with following the rules, it is not grave abuse of discretion on the part of the judge. Yun yung gusto kong iparating dito na hindi ko maintindihan bakit grave abuse of discretion yung ginawa o nangyari doon sa judge, no? Wala naman siyang kasalanan kasi nga sinusunod niya lang yung batas. Di ba? Petitioner claims that a relaxation of the rules is warranted in his case as he is not guilty of the crime charge and was wrongfully convicted thereof. Tingnan mo, ang hinihingi dito, relaxation of the rules. Bakit may grave abuse of discretion on the part of the courts? Ito, sabi niya, given na ito, na prosecution failed to prove that the arthroscope used on private complainants sa Olifenia was not sterile. There was an assumption lang daw. Pero, may failure daw na i-observe yung due care and diligence required of him under the circumstances. It is was ruled that private complainant failed to present evidence to establish the standards in medical practice regarding the sterilization of subject instrument. Nag-fail din sila yung inspection ni Hopelenia, no, ni was due to petitioner's alleged negligence during the arthroscopy. The prosecution failed to identify and present the person who allegedly took the sample, blah, 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 blah. Ito, technicalities na. Itong arguments naman nila, was fatal. Sabi niya dito, on the other, respondent argues that the petitioner's failure to attach the pertinent documents cited by the appellate court in its April 29, 2014 resolution was fatal to his cause. Petitioner failed to submit all the lacking requirements without any plausible explanation when he failed and when he filed a motion for reconsideration on April 29, 2014. Respondent insists that petitioner's counsel's excuse of heavy workload, almost daily court hearings, and submission of equally important pleadings ay okay. Yun kasi ang sinabi niya, heavy workload, daily court hearings, submission of equally important pleadings. Ito yung ruling, petitioner without merit. Bakit? Sinabi niya dito, hindi nila man na dininay na nagkamali sila nung hindi sila nag-attach ng mga documents na yun. Tapos, nag-file siya ng motion for reconsideration, hindi pa rin nila i-file yung mga affidavits. Evidence of the prosecution, petitioner's comment and opposition thereto, and petitioner's answer. Yun ang problema. Kasi syempre pag hindi nyo in-attach kasi itong mga ito, walang pagbabasihan yung korte. Kung walang pagbabasihan yung korte, madidismiss talaga yung kaso nyo. Sabi niya dito, consideredly, any infirmity on the form of the petition may be waived to give chance the parties a chance to argue their cause and defenses on the merits. The concerned parties must, however, offer a satisfactory explanation and subsequently comply with the requirements to justify a relaxation of the rules. Marami kasing trabaho daw yung abogado. Shall be a ground for dismissal. Ito kasi inulit lang yan. Ito nga, heavy workload. Does not persuade. Ito rin, inulit din. Inulit din yung mga sinabi sa Court of Appeals, no? Stress that an appeal is a statutory right. And the party who intends to appeal must comply with the rules and procedures. Ito na, mga kabatas natin, no? Finally, petitioner raised the issue of the non-sterilization of the arthroscope he inserted on Hopelenia Jr.'s knee during the operation, which may have caused the growth of bacterial infection on the latter's knee. Well settled is the rule that in petition for review on certiorari under Rule 45, this court only dwells on questions of law and not questions of facts. Yun ang problema. Wala silang ano eh. So, pero ang mangyayari talaga dapat dito, ang prayer dito i-remand doon sa baba para magkaroon ng trial on the facts of the case na naman. Kaya lang, yun. There is a question of law when doubts or differences arise as to what law pertains to a certain state of facts, and a question of facts when the doubt pertains to the truth or falsity of alleged facts. Obviously, the sterilization or non-sterilization of the arthroscope is a question of fact, as it involved a review of the probative value of the evidence presented before and considered by the MTC, the METC. Besides, petitioner had the opportunity to raise factual issues before the RTC and the CA. However, he failed to take advantage of the opportunity when he unjustifiably and unmeritoriously failed to submit an appeal memorandum. Yan ang sinasabi ko sa inyo kung bakit importante ang appeal memorandum. Your arguments will rely on it. In fine, we hold that the appellate court committed no reversible error when it dismissed outright petitioner's appeal for lack of merit. However, we deem it necessary to modify the penalty imposed by the METC. Aside, Article 365 of the revised penal code provides imprudence and negligence, blah, 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 blah. So dito, merong reversal. Ang nangyari dito, 1 month and 1 day of arresto mayor as minimum to 1 year and 1 day of prison correctional as maximum. Indeterminate, based on the indeterminate sentence law. Yun, mga kabatas natin, ano, tulad ng sinasabi ko, pinag-aaralan lang naman natin ito para mas mahasa yung ating critical thinking at saka syempre yung ating kaalaman sa batas. Pag makikita nyo dito, parang binigyan naman na kasi ng chances. No? Binigyan niya ng sunod-sunod na tsansa si Dr. Agbayani dito. Kaya lang, up to the Supreme Court, mga kabatas natin, there was no compliance of what is required of them. Kaya, syempre, the Supreme Court is tied with nothing. They have no recourse but to dismiss the case. Di ba? Sabi ni, what is inside LTD? So, okay, he failed to appeal in time daw, even though he's obviously innocent. Well, the innocence, like I said, it was not argued. Diba? It was not argued. Sabi ni, ito. So, in summary, Doctor, no, that's the wrong summary. Was jailed and died because the judge on his discretion decided not to hear out the evidence. No. The problem there is they cannot base anything. They cannot make a reversal or they cannot make a ruling aside from dismissal because they have nothing to base it upon. Walang na-submit na mga documents, walang na-submit na memorandum, so they cannot base it on anything. Diba? Ito sabi ni, madami na binigay sa kanyang chance. There was. Yeah, even sa Court of Appeal, sabi nga ng Supreme Court dito. Sabi ng Supreme Court dito, doon sa Court of Appeals, pwede ka rin naman sanang nag-argue, nagkaroon ng arguments. Kaya lang hindi pa rin pumasok. Di ba? Ito ang magiging problema dyan, no? Lesson, piliin ng pasyente kung abogado, ipasa sa iba. Ito sabi niya, no, they cannot make a reversal of or ruling aside from dismissal because there is nothing to base it upon. There were documents submitted at MTC level. Yeah, but the documents submitted in the MTC level was rolled upon by the MTC and the MTC said that there is conviction. Now, syempre, you also have to argue why it should be reversed. Tandaan nyo, the court will not argue for you. So ganito kasi, no, what is inside LTD, no? Ito ang problema diyan. Kung wala kang argumento, anong gagawin ng korte? If you will base it from the ruling, from the documents that were submitted with the MTC, it was reviewed and taken into consideration already by the MTC. And the MTC said there should be conviction. Yun ang sinabi niya, di ba? Ngayon, it is up for you to argue now kung bakit ma-reverse dapat yun ng Regional Trial Court. RTC will not argue for you. RTC will not argue for you. Ano yun? Mag-aabogado yung Regional Trial Court laban sa Metropolitan Trial Court? It doesn't work that way. You should raise your arguments. Now, because you did not raise any arguments, what will they base their decisions upon? Alam nyo, kung ganito ang nangyayari, ang ginagawa ko, you submit everything already. Pag magfa-file ka ng motion for reconsideration, no? With motion to admit attached. appeal memorandum. Para meron silang basis. Makikita nila kung meritorious ba yung argument mo o hindi. Kapag wala yon, RTC will not argue for you. Sabi niya, have you seen the evidence at MTC level? No, but the MTC saw it. And I trust the MTC. Just like the Supreme Court trusted the Metropolitan Trial Court. Di ba? Yan, your argument will not hold water. Yung have you seen the evidence presented? I don't need to see the evidence presented. I just have to read this. And I know and I will know that there was conviction, and because there was conviction, it means there was proof beyond reasonable doubt. Now, if there was not, then you have to argue otherwise with the regional trial court. Nobody will argue except you. Yung apelan. Di ba? Yung apelan. Ito sabi niya, I'm out of here. You are clearly biased just looking at one part of the whole argument. Tell us how it is fair that he was convicted of imprudence for 2 years. Well, it was modified by the Supreme Court. That is the reason why there is an appeal as the remedy. And if you say that I am biased because I am biased with the law. And like I said, what I'm reading here is a Supreme Court decision, and this forms part of the law of the land. So I am biased here. Diba? Good for you. You trust the system. I'm out of here. You are clearly out of your depth. Yeah. Good riddance. Hindi, joke lang. Joke lang. Di ba? Pero yun. Ito sabi ni Brett, biased as if si attorney nagbigay ng decision sa kaso. Well, I am bound by the Supreme Court decision, like I said. Sabi niya, kung hindi pa baya ang abogado, bakit walang attached documents? At bakit sa daming chances na binigay, bakit walang actions? Ito, yun eh. Parang may kilala akong ganyan eh, makikipag-argue. Tapos pag nasasagot yung arguments niya, out of here na lang. Parang meron akong ganyan, tapos kakalimutan na lang. Yun ang problema dyan eh. Pahiya, aalis na lang talsor. Di ba? Ganon yun. Kapag, if you want to argue with anyone here, pangatawanan mo. Hindi yung iyak uwi. May kilala rin akong takbuhin. Di ba? May kilala akong takbuhin. Anyway, mga kabatas natin, no, naging extra na tuloy because I just want to I just want to expound on this one para maintindihan lahat ng mga tao kung ano yung nangyari. Ngayon, syempre, yung lawyers as patients, we cannot do anything about that naman na. Di ba? But I still believe naman na there are many doctors pa rin who will really uphold the Hippocratic oath and practice it by heart. Okay? Yeah. Bakit inaaway niya si Atty. Libayan? The SC decided that the evidence isn't enough. Kaya nga convicted, proven guilty. Hindi naman evidence isn't enough, no? there was evidence sufficient enough for guilt according to the Metropolitan Trial Court. Kaya lang there was no arguments eventually why the decision of the Metropolitan Court should be reversed. Okay? Yun ang issue dyan. Yung bakit 2 years, of course, that's the reason for the appeal. Judges also commit mistakes kung hindi nga dapat 2 years, di ba? Up to 1 year lang. Yun pa rin ang problema. Tao pa rin sila. That's why there is an appeal. If there was a mistake, then there should be change. Okay? Yeah, maraming salamat mga kabatas natin. No, siyempre, tulad lang yung sinasabi, matulog po tayo ng mahimbing. Dahil alam natin na yung natutulog ng mahimbing, siya yung laging panalo. Paalam po, pansamantala.